you share the link everywhere. I'm trying to share it places, but I'll miss some trying to rush. A big drop of documents have come out. Share it far and wide. We'll be starting in just a second. Let me finish sharing this out.
What you think about when you're born into a fire? Let them burn it out. Sell them to the richest buyer. They want to let the world decay. They tell us lies and fade away, fade away. We feel betrayed. We were raised to lose the race. Wake at the back of the pack, kill it anyway.
Oh, that's my bad. I threw on the wrong one.
Because we're never dropping out. Beat the odds, beat the big house.
All right, guys, here we go. A big set of documents has dropped. One that's just 6 pages long and another one that is 144 pages long. The Scranton Times coming out with all their evidence against Phil GODLEWSKI that this case should be dismissed with prejudice. We're going to go over it quickly. I'll try to go through it quick and not get sidebarred or whatever. Just know, before we get started, if you want to support the show, just like, comment, share, send this to somebody, leave a comment. If you're watching the replay, leave a comment. If you want to go above and beyond that, that's up to you. You can go to coldbeer.fund and support the show. It hasn't been, we've been having a couple of rough starts to our holiday season, I guess. So if you want to support the show and keep it on, if you get something out of the content, you're more than welcome to go to coldbeer.fund, coldbeer.fund. You can find it in the description. Now, this is their second motion for sanctions because of discovery. So what happened is Phil brought this case against them. They have every right in the world to get discovery towards potential evidence that may pop up or that may come up in the case. Who's going to be witnesses? What are they going to use? What paperwork? What are they doing? And it seems as if Phil GODLEWSKI is refusing to comply with orders to do this. And there's some other issues too. So let's get started. Second motion for sanctions. I'm going to skip over a lot of the technical stuff and signatures and duplicates, just so we can get through this large document. Defendants Chris Kelly, Tom Shamrock Communications, Scranton Times Tribune, Larry Holeva, by and through their attorneys, Haggerty, Hinton, and Cosgrove LLP, filed a second motion for sanctions against the plaintiff. One plaintiff, Phil GODLEWSKI, filed a defamation case against the defendants on May 24th, 2021. I could zoom in some. I don't know how good you guys can see it, but May 24, 2021. Plaintiff alleges defendants defamed him in an article published on February 14, 2021, Valentine's Day, Times Tribune newspaper, and he seeks $5 million in damages. This article is attached to the complaint. By virtue of him being a self-proclaimed patriot reporter and social media influencer with over 75,000 followers, Plaintiff admits in his complaint he is a public figure. Complaint 2 and 89. 4. The article in question discusses the plaintiff's criminal history and states Lackawanna County detectives said Godlewski had sex with a minor girl in cars and homes he had access to as a real estate agent. 5. Further, the article stated plaintiff pled guilty to corruption of a minor in 2011 and admitted to having a sexual relationship with a 15-year-old girl. 6. The article stated Godlewski, 28 at the time, was sentenced to 3 to 23 months, with the first 3 months to be served under house arrest and the balance as probation. 7. A copy of the criminal complaint filed with the court following a plaintiff's arrest on July 9th, 2010 is attached here too, marked as Exhibit A. The name of the minor victim was redacted in the criminal complaint released by the clerk of courts. 8. The corruption of minors charge was due to Philip Godlewski engaging, quote, in sexual intercourse with a minor child victim. See Exhibit A, page ST616. 9. Plaintiff did in fact plead guilty to the corruption of a minor charge pursuant to a plea bargain to dismiss the other charges. The sentencing sheet directed him to have no contact with the victim. A true and correct copy of the guilty plea colloquy and sentencing sheet are attached hereto and marked as Exhibit B. 10. Plaintiff was more than 10 years older than the minor victim, BD. 11. Plaintiff now claims in this lawsuit he never had sex with BD, and defendants defamed him by stating such in February 14, 2021 article. 12. Plaintiff's complaint states significantly, defendant Kelly could not have stumbled upon the fact Mr. Godlewski had sex with a 15-year-old girl when he was 25 years old because that never happened. That's in complaint 47. 13. A primary allegation in plaintiff's complaint is that the article defames him by stating he had sexual intercourse with a 15-year-old girl in 2011. 14. Plaintiffs raised $26,396 to bring this lawsuit through his crowdfunding campaign, social media donation request, based on his representation that he had been libeled in a news article referencing criminal charges that were ultimately dismissed. A true and correct copy of plaintiff's crowdfunding campaign is attached here too, marked as Exhibit C. Plaintiff's campaign conveniently left out the fact that he pled guilty to corrupting a minor's morals. 15. The complaint states Mr. Godlewski is married with 3 children. 16. Plaintiffs have verified supplemental answers to the questions set 1 state Dory, plaintiff's wife, left February 17, 2021, right after the article went public. A true and correct copy of plaintiff's verified supplemental response to defendant's request for production of documents set 1 dated 12/9/21 is attached here too, marked as Exhibit D. See page 4. 17. Plaintiff is essentially claiming his wife left him due to the article. 18. On May 3rd, 2022, plaintiff did an audio show which was broadcast to thousands of his followers, and he said this girl, the 15-year-old girl mentioned in the article, was conniving. And the 15-year-old girl and her friends used an internet text messaging app to make it look like the plaintiff was having text message conversations with the girl about, quote, nasty shit. And that led to the 2010 criminal charges against him. 19. In a May 3rd, 2022 Telegram voice chat, which was broadcast to thousands of people, plaintiff said the minor's victim's mother saw dollar signs, implying the mother caused the criminal sex charges to be filed against him in 2010 for financial gain. 20. Plaintiff filed his complaint in the case on May 24, 2021. 21. On June 8, 2021, defense counsel served plaintiff counsel with preservation of evidence letter directing plaintiff to preserve, do not destroy any evidence, quote, about the lawsuit, the defendants, the article, any criminal charges ever filed against Philip Godlewski, and Philip Godlewski's separation from his wife. End quote. This letter specifically directed plaintiff to preserve all of electronically stored information, including any relevant information on a smartphone or mobile phone. A true and correct copy of the preservation of evidence letter dated 6/8/2021 is attached hereto and marked as Exhibit E. 22. On June 17, 2021, plaintiff's counsel wrote to defense counsel acknowledging receipt of defendant's preservation of evidence, and that the copy of that is attached also. 23. On July 9th, 2021, defendant served plaintiff with a set of questions. Set 1, a true and correct copy is attached. 24, the first page of the question states, these questions are continuing in the nature and require you, plaintiff, to file a supplementary answers pursuant to Rule 4007.4. 25, the instructions for the question stating, If privilege or work product doctrine is asserted with respect to a document or communication, state the following. A, the nature of the privilege or reason for the withholding which you contend applies. B, the factual basis for your assertion of privilege or the reason for withholding. C, the type of document, e.g. letter, memorandum, telex, etc. D, all persons to whom the document was distributed, shown, or explained. E, all authors and addresses. F, all indicated and blind copies. G, the document's date. H, a summary description of the document's subject matter. I, number of pages and attachments or appendices. Appendici? Whatever. Compromising the document. And J, its present custodian. So what this is saying is if he can't answer a question or refuse to answer your question or refuse to comply with discovery, that he has to fill out all this shit, right? He has to fill all this shit out. The nature of the privilege, the factual basis for that privilege, the document, the type of document, all persons who've seen this document, shown the document and explained, all authors and their addresses, all indicate. Instead, his lawyer just says, I think this is cumbersome and overbearing and will lead to no evidence. That doesn't cut it. D, in the event that any document requested to be identified in any question has been destroyed or discarded, such documents shall be identified by stating all of the information requested in subparts C through I of the instruction C, and in addition, K, its date of destruction or discard, the manner of destruction or discard, and the reason for destructing or discard. The persons who authorized and carried out such destruction or discard, and M, whether any copies of the document presently exist, and if so, the name of the custodian of each copy. You can't just say, I'm not doing it. You can't, especially when being ordered to do it. 26, plaintiff's verified response to defendant's first set of questions were served on defendants on August 20th. Got a copy attached. Plaintiff's response to questions 32 and 33 are as follows. Did the 15-year-old victim, who was the subject of your 2010 criminal charges, touch you in any sexual manner at any time during the years of 2008 to 2010? Answer, no. Did you have any letters, emails, or text messages from the 15-year-old girl? Answer, none. Plaintiff has never supplemented these specific answers to the questions. On July 12, 2021, defendant served defendant's request for production documents set 1 upon plaintiff, referred to hereinafter as RFP 1. A copy is attached. RFP 1 number 20 requested any documents sent to or from the 15-year-old girl referred to in the article attached to your complaint. RPF 1 identifies documents to include external communications or inter-office communications, letters, telefaxes, telexes, emails, cables, telegrams, wires, memorandum. The definition of a document certainly includes text messages. 32, plaintiff served defendants with plaintiff's response to defendant's first set of requests for production documents on August 20th. A copy is attached. Plaintiff's response to RFP 1 number 20 incorrectly numbered as 19 in plaintiff's response stated. Any documents sent to or from the 15-year-old girl referred to in the article attached to your complaint? None. In plaintiff's verified supplemental response to defendant's request for production documents dated 12/9/2021, as for the, quote, sexual relations or, quote, intercourse or, quote, sexual and illegal intimacy, there are no documents because it never happened. That was Phil's answer. On June 24, 2022, defendant served plaintiff with defendant's request for production of documents set 4, a copy attached. On 8/22/2022, plaintiff served his verified response to defendant's request for production documents set 4 and answered number 7 as followed. Produce any text messages between Phil Godlewski and BD, that would be the victim, between 1/1/2008 through the present day. Answer, plaintiff does not have any. A copy is attached. On November 4, 2022, defendant served plaintiff with defendant's question set 3, a copy attached. On November 9th, plaintiff served defendants with his verified responses to the question set 3, copy attached. Plaintiff answers the question set 3, number 2 and 6 are as follows. Does plaintiff still have the cell phone number 570-780-4567 in use? Answer, yes. Has plaintiff communicated with BD? So this is the fourth fucking time they've asked him if he's communicated with the girl he was accused of. With BD about his lawsuit or his damages in the article. Answer, yes. If plaintiff answers yes, please state the dates of such communications, the form of such communications, live, in person, phone, text, or email, and the substance of each communication, such participant stated on each specific date of the communication. Plaintiff does not recall the specific date of the communication. Plaintiff spoke with BD, the victim, in person regarding the filing and warned that it was imminent. Plaintiff asked the victim, would rather plaintiff forego filing so as to avoid any stress in her life. The victim said to file so that they could both set the record straight. That was Phil's comments. On October 28, 2022, the minor victim contacted defense counsel by phone and advised him she had asked plaintiff to stop telling lies about their relationship. She wanted me to know the truth about her plaintiff relationship, or her relationship with plaintiff. On October 28th, the minor victim contacted defense counsel by phone and advised him that she had asked Phil to stop telling lies about the relationship they had. She wanted Scranton Times to know the truth about her relationship with the plaintiff. The victim then met with defense counsel on Halloween 2022. On October 31st, 2022, the victim provided information to defense counsel about her relationship with Phil GODLEWSKI. That information was included in her affidavit that she signed on October 31st, 2022. A true and correct copy of the executed affidavit is attached hereto, marked as Exhibit O, with her name and date of birth redacted. The court and the plaintiff's counsel have been provided with this information redacted on the affidavit. Are you shitting me? Phil told you guys that this was all a lie. They made it all up. It was internet text messaging apps, and that they were good friends now. She has now reached out to Phil and told him to stop telling lies about him, and is now testifying on behalf of the Scranton Times, even though Phil said she was going to be a character witness for him. The affidavit clearly states that the victim began having a sexual relationship with Philip GODLEWSKI when she was 15 years old and a 9th grade student at Riverside High. Philip GODLEWSKI was 25 years old when this relationship began. Defendants have also subpoenaed plaintiff's employment records from Riverside School District, where Phil GODLEWSKI worked as a part-time JV baseball coach. In response to the subpoena, Riverside School District provided numerous records, including a letter from the victim's parents dated 1/27/2009, and phone records showing upwards of 300 text messages between Philip GODLEWSKI and the plaintiff on just one day. 300 messages on one day. Copies are attached. On October 31st, 2022, the victim showed defense counsel her text messages on her cell phone with Phil GODLEWSKI in the year of 2022. On November 2nd, 2022, the victim consented to have her cell phones downloaded, and she provided her 2 cell phones to a technician from 2x2 Solutions LLC Image, and a copy of all her instant messages, text messages with Phil GODLEWSKI on those 2 phones. The technician was able to download 1,235. Carrie, you know he's still texting this girl 1,235 messages between the two? Just this year, in 2022. Between Phil and the victim from March 31st, 2021 to May 11th, 2022. And 151 instant messages from May 28th, 2022. She must have changed phones in May. From May 28th, 2022 to September 9th, 2022. The unredacted instant messages, pictures, and videos have been provided to plaintiff's counsel and will be presented as evidence at the hearing to be scheduled by the court. Some of the messages and attachments between plaintiff and the victim, between Phil and the victim, are sexually explicit and graphic. In the year 2021 and 2022, There are sexually explicit and graphic messages between the former 15-year-old that claims she had a sexual relationship with Phil Godlewski and Phil Godlewski, the fucking QAnon cult leader. On March 31st, 2021, plaintiff wrote to the victim, Phil wrote to the victim, I had no idea your papa, her grandfather, died. I'm so sorry. I think we had sex in their bed. Uh-oh. Trouble in paradise, Carrie? I'd take that fake-ass ring off, too. I think we had sex in their bed, though. A copy is attached. And imagine that. It ends up being Exhibit Q. It ends up being Exhibit Q. In another message, they discuss, quote, we've probably had sex in like 40% of the homes in northeastern Pennsylvania. A copy is attached. In another message, Phil and the victim agreed that had been a, quote, very long time since they'd been up under each other. A copy is attached. On March 31st, 2021, plaintiff sent the victim a photo of his erect penis and wrote to the former victim, yeah, I think it got bigger. Not sure if that's a thing, but it feels like it did. Phil Godlewski sending dick pics to the victim that he was charged with in 2010, trying to convince her that he doesn't hate his penis anymore because it grew up. No, Edward Snowden, I think he's an angel sent here from the great galactic heaven war between good versus evil and Satan. And he's an angel sent here to show us the way. In April 2021, plaintiff invited the victim to go to Oklahoma with him. I've heard about this. I couldn't say anything because I had no idea whether it was true or not, but I heard about this. With regard to plaintiff's claim his wife left him due to the article, Phil wrote to the victim on March 31st, 2021, I feel better that she's gone, to be honest. The sex sucked or was non-existent, but always one of the two. She was constantly miserable. She wasn't even really a great mother. The kids always wanted to be with me, not her. It was a disaster. Copy attached. In the instant message between Phil and the victim on May 28, 2022, plaintiff advised the victim of a, quote, very unique financial opportunity and a, quote, financial windfall for both of them if their testimony in this lawsuit is, quote, handled properly. He was going to pay her. He was going to pay her. Phil said, I don't know which way to go with it until I speak to you. Quote, I don't trust those motherfuckers, and I am literally foaming at the mouth to take them down once and for all. A true copy is attached. 58, on the day the newspaper article was at issue, here was published, 2/14/2021, plaintiff wrote to his followers, quote, I would be suing the Scranton Times Tribune for defamation and libel. I was hoping the reporter would do exactly what he did. He took the bait. A copy is attached. Phil knew that the victim stopped cooperating with the district attorney's office back in 2011 in the criminal case against the plaintiff, and he counted on her not cooperating with defendants at the present time. Wrong. Wrong. Only this time the victim is now an adult, and she did not go along with his scheme to defraud the defendants and tell falsehoods in court proceedings. She is now on the record with the truth. They were involved in a sexual relationship when she was 15 years old and he was 25 years old. On August 20th, 2021, you're done, Phil. This case is over, bro. She's working with the Scranton Times and she's got the receipts, bro. After a preservation of evidence letter was served to plaintiff, plaintiff answered question 33, Exhibit H, stating he had no text messages with the victim. The answer was either a lie or he destroyed the text messages in violation of the Preservation of Evidence Directive, and he failed to disclose the destruction of his text. Phil and the victim had over 650 messages between March 31st, 2021 to August 13th, 2021. Documents marked as ST-1021 and ST-1255 will be submitted to the court as evidence for the hearing. The text messages contain...
Malistrom wants to know, can his case be reopened or a new case brought based on these revelations?
I don't know. The text messages contain sexually explicit content, photographs, and a video. All of these messages have been provided to the plaintiff in unredacted form. They sent this motherfucker his own dick pic back to him. Like, gotcha. From Chris Kelly at the Scranton Times. Here's your dick pic you sent to the victim. These text messages did not slip plaintiff's mind. He intentionally failed to disclose them in discovery for his lawsuit. Plaintiff's response to RFP 1, number 20, incorrectly numbered as 19 in plaintiff's response on August 20, 2021, is false and deceptive. Plaintiff's verified response states he has no documents sent to or from the victim. He either withheld the documents or he destroyed them. On August 22nd, 2022, plaintiff again provided a false discovery response when he claimed he had no text messages with the victim. He had well over 650 messages with her since March 31st, 2021, and 52 text messages from 8/5/22 to 8/18/22. That's ST 1476 to 1494 will be submitted to the court as evidence at the hearing. This is an intentional concealment by Phil GODLEWSKI. The victim wrote Phil GODLEWSKI on 8/6/2022 stating, "All I ever wanted from you is to please stop calling me a liar and making me look like an asshole when it's not true." This will be submitted as evidence at the hearing. On November 9th, 2022, plaintiff answered a question describing his only communication with the minor victim since the Chris Kelly article was to warn her about the plaintiff filing a lawsuit and offering to forego the filing because he's a gentleman if it would cause her stress. Plaintiff's claim she told him to file so they could set the record straight. This is obviously false. Not only did Philip GODLEWSKI commit a sex crime against a 15-year-old girl in 2009 to 2010, he has now solicited the same person to commit perjury in a court proceeding so he can enrich himself. Let me read that again. Not only did Phil GODLEWSKI commit a sex crime against a 15-year-old girl in 2009 and 2010, he has now solicited the same person to commit perjury in a court proceeding so he can enrich himself. On November 10th, 2022, defendants served plaintiff with questions set for a true and correct copy. Plaintiff served defendants with plaintiff's response to set for on November 18th, 2022, a true and correct copy. Plaintiff denied ever having a sexual relationship with the minor in his questions answered. Plaintiff's text message and the attachments between between Phil and the victim in 2021 and 2022 tell a different story. This dumb fuck not only lied about the whole thing and tried to convince his audience, not only crowdfunded the whole thing and tried to convince its audience, not only went through all the steps and tried to get her to go along with it while he was doing live streams, calling her a conniving, calling her a bitch, calling her mom money hungry, he still ended up sexting her. And you're going to tell me, Carrie, with 2 minor female children in the house, and you trying to get married to this man, you're cool with this? Who's the captain now, motherfucker? Who's got egg on their face? I thought we were almost being disposed. It's deposed. You keep saying it wrong. Fucking Captain Eggface. Wherefore, defendants respectfully request the following. A hearing should be scheduled at which plaintiff be compelled to testify about whether he failed to preserve or produce relevant discovery materials requested in this case. Plaintiff surrender his cell phones he utilized For phone number 57, I told you guys, when they ask the lawyers do not ask a question they don't already know the answer to. Lawyers do not ask a question they don't already know the answer to. I do the same thing when I talk to Phil. I already know the fucking answer. That's why I'm asking the question. When they asked is this still your number, they didn't need, they knew it was his number. They knew his phone records. They knew how to contact him. They knew his records could be found on public databases and his phone number included. They needed him to admit that it was still his current phone number because they already had her and her fucking text messages in their hands. Plaintiff surrender his cell phone he utilized for phone number 570-780-4567 during the years of 2021 and 2022 for the forensic examination and or an in-camera review by the court at the hearing. Defendants be given the opportunity to present evidence and witnesses at the hearing. Plaintiff's case be dismissed with prejudice, so he can't bring this again if the court determines plaintiff intentionally withheld or failed to preserve material evidence. And defendants be awarded $35 or $35,000 from plaintiff as reasonable counsel fees and another $35,000 for plaintiff's bad faith conduct due to the plaintiff filing this lawsuit, intentionally failing to produce evidence, providing false discovery responses, and for suborning perjury from a material witness. It is a criminal offense to offer a financial windfall for someone to testify on your behalf, Phil GODLEWSKI. No wonder you took the last 2 weeks off. No goddamn wonder you told us you had been called up to the Trump team. You'd been called to your lawyer's office, and he's over there thinking about starting a fucking pistol because the mess you got him fucking tied up in now. Not that he was that good of a lawyer to begin with. Let's look at the evidence. That's certificate of compliance. That's more. Let's see what we got here. Police criminal complaint. We've seen this before. Accused above defendant who lives at the address, blah, blah, blah. Each act is described. In that, on or about January 2008, the president, the defendant, Phil GODLEWSKI, did engage in a sexual intercourse with a minor child while said person. Remember when I told you guys that it doesn't matter what he personally believes. It doesn't matter what him and his fucking grandpa claim or him and his dad claim or his family's agreed to say about the situation. Oh, he didn't have sex with her, but he took the charge just because, they were going to railroad him. Okay? That's like me pleading guilty to murder for murdering someone. And then when I get out trying to sue somebody because they said I murdered someone. Well, I didn't really. I just took the fall for it. I can say that all I want. But the charges you took are attached to documentation that lays out the actions you committed. And when you plead guilty to those charges, you're also admitting that you did those things. I don't give a fuck how you feel about it or what you tell your followers about it. You can lie all you want. But when these charges were brought, they were specifically brought about you engaging in sexual intercourse with a minor child while the person was under the age of 16 years old. And you pled guilty to one of those charges on that fucking bill of charges. You can't now retroactively say, well, I just did it because my grandpa told me to on a bench in front of the courthouse. No one gives a fuck. Under the age of 16 years, 4 or more years younger, and not being married to the actor in violation of Section 312. We've read this before. This is the criminal complaint. He did engage in deviant sexual intercourse per OS, per anus, with a minor child, while said person was being less than 16 years old, in the age of 4 or more years, not being married. In or about January 2008, the defendant, Phil GODLEWSKI, did engage in penetration, however slight. That's when he hated his penis, and before it grew up. So I would say we're leaning heavily on the however slight of another, namely minor female child, while said person being under the age of 16 years, 4 or more years younger, not married. The acts committed by the accused. Statute, description, acts. Oh, that's all of them. Blank under the age of 16 years old. She was associated with the offense. Offense defined: a person commits the offense if he intentionally in contact with a minor, personally engaged in an act prohibited under the following, and either the person initiating the contact or the person being contacted is within the Commonwealth. In that, January, the defendant, Philip Godlewski, with intent or knowledge that his conduct would obstruct, impede, impair, prevent. So this is about him.
Oh, my nephew made a meme.
Thank you very much.
Yay! Thanks, nephew.
Fuck you, Phil Godlewski. Great job, Will. Thank you for keep doing what you're doing. That's Kelly. Kelly bought you 5 6-packs. Thank you very much for the donation and the support. These are the other charges where he tried. They tried to charge him with intimidating a witness and all that stuff. And Phil claims it didn't happen. They didn't have any evidence. The offense is a felony degree indicated in paragraphs. Blah blah blah. The actor accepts, agrees, solicits, another accepts pecuniary. Or other benefit, intimidate a witness. Description acts. I don't want to skip over anything, but to wit, the Godlewski did instruct the victim to have her tell law enforcement all conversations they had between them were fake. Godlewski told the victim she is the only one who can get him out of this. Defendant did tell the witness to contact the victim to get their story straight. Being 18 years of age, tend to corrupt the morals of a minor victim, a minor child, indecent contact with the person, and intentionally cause. So even his corruption of a minor has to do with sexual contact, sexual intercourse, by engaging in acts of sexual intercourse. So even the plea he took, I know there are different levels of corrupting a minor. I get it. Here's the one he pled to. In that, on or about January 2008 to present, the defendant, Philip Godlewski, being 18 years of age and upwards, did corrupt or tend to corrupt the morals of the victim, a minor under the age of 18 years old, by engaging in acts of sexual intercourse. What's that about that M1 that you didn't plead to? I gotcha.
Dumbass.
Skipping back through that, that's all his charging document. Affidavits for probable cause, Detective Michelle Mancuso being employed by Lackawanna. We've read this too. This is where she spoke to the victim, and it gives her background and her showing up at CPS, I believe, Child Advocacy Center, and talking to the victim. The interview began with a few tears, stated she had disclosed some personal things that she has been involved with her mother, Linda. Stated she was very upset talking about the situation. Stated been involved in a sexual relationship with Phil Godlewski. She stated he was a realtor and that they met while he was the baseball coach at Riverside High School in 2008. We've read that. This is the other one. This is the other detective that ends up telling her that Phil's lying to you. He didn't leave Dory because apparently she was under the impression, she claims Phil told her that if she got him out of trouble, he was leaving Dory. They would start dating. They would live their lives together. That was all a lie. Affidavits of probable cause, including the text message. I just want you to see that I really care about you and not your body or our sex. Maybe that's the only way I can. I need you, blank. I need you more than anything in my life. I'm going to do everything I can to be with you as soon as I possibly can. And you're my drug. I'm addicted, to quote a dear friend. Godlewski says, I hate my penis. I don't know why the fuck that happened. You look so good and we're giving incredible head. Then boom, gone like what the fuck. Godlewski typed a 2-page day log with times and entries. Godlewski then gave this log to the victim. The day log includes detailed account about his activities and thoughts throughout the day. The following are excerpts from the log. 10:14, realize that you're only 15, but quickly stop caring. 10:34, got sad because we can't officially go out. I just want everyone to know that I love you. 11:39, I just pulled blank hair from my crotch area. Ha ha ha. 2:56, should we get a jacuzzi suite? 3:56, why can't you be 21? 5:28, why are we so compatible? I'm 10 years older than you. We've seen that evidence. You are present before this court because you or your lawyer has stated that you wish to plead guilty to some of all of your criminal offenses with which you have been charged. Please answer fully all of the questions on this document. If you do not understand any question, do not answer that question. If you do not understand the question, you should answer yes or no, or fill in another appropriate. If you do understand the question, answer yes or no, or fill in an appropriate answer. This is a sworn statement. After you have finished reading this form and filling it out, you should sign it on the last page on the line that says defendant. You should also initial each page at the bottom, but only if you have read and understand that page. If there's anything that you do not understand, you should tell your lawyer and the judge who hears your case so that they can explain it to you fully to make sure you understand all of your rights. Most of these questions can be answered yes or no, where general information is requested. Please answer. This is a sworn statement, a guilty plea. A guilty plea. What is your full name, Phil Godlewski? Do you wish to plead guilty to the charges of corruption of minors as laid out in the criminal action against him? Yes. How old are you? 27. How far did you go to school? College or grad? Uh-oh. Do you read and write English? Yes. Have you had an opportunity to read the charges pending against you? Yes. Therefore, do you know exactly what you are charged with and that you are pleading to? Yes. Have you ever been in a mental institution or received treatment for a mental disease? No. Have you had any alcoholic beverages or drugs in the last 24 hours? No. Have you fully discussed your case with your attorney, and are you fully satisfied that he knows all the facts of your case and he has had sufficient time to look into any questions either he or you may have about your case? Yes. Signed, Phil Godlewski. Are you satisfied with your attorney? Yes. Do you understand that even though you are guilty or you may be guilty, you are presumed innocent and have the right to go to trial either before the judge or before a jury of 12 individuals, and the Commonwealth must prove to the satisfaction of each and every one of the 12 jurors or to the satisfaction of the judge that you are guilty beyond reasonable doubt? Yes. Do you understand that you and your jury or your attorney have a right to participate in the selection of a jury? You never signed that one. Do you understand that if you want to go to trial, your attorney will be permitted to cross-examine the Commonwealth's witnesses and to call witnesses on your behalf? But if you plead guilty, you will lose that right to call witnesses or to cross-examine the Commonwealth witnesses? Yes. Do you understand that by pleading guilty, you are admitting that you did things you are charged with, and that if you plead not guilty, the Commonwealth cannot force you to take the stand or either admit or deny that you did the things you're charged with? Yes. Do you understand that by pleading guilty, you are giving up your right to appeal any question in this case except for those concerning the right of this court to try you, jurisdiction over subject matter, or the legality of proprietary of the sentence imposed? Yes. State specifically in detail any plea agreement with the district attorney. Plead to corruption of minors. Agreed to be sentenced to 3 months home confinement to 23 months. All other counts dismissed. Has the district attorney made any other promises to you in exchange for your guilty plea other than what is mentioned? No. Have you been threatened or coerced in any manner to enter this plea? No. Are you entering this guilty plea of your own free will after discussing the merits of your case with your attorney? Yes. Do you understand that the court is not bound by the agreement you made to the district attorney? Yes.
Uh-oh.
Do you understand that the maximum penalty to the charges you are pleading guilty to is 5 years, $7,500? If you are pleading guilty to more than one charge, do you understand that the judge may impose NA? If the answer, NA. Do you understand that certain crimes carry mandatory minimum, NA? Did your attorney advise you that the mandatory minimum penalties, NA? If you answered yes, NA. The elements of the crime charged are as follows. Being of the age of 18 or older, something act corrupts and find to corrupt the morals of a minor. Being of the age, this is Phil's headline. Being of the age 18 or older, by my act, corrupts and tend to corrupt the morals of a minor. Okay. And tend to corrupt the morals of a minor. We got that one. Do you understand these are the elements of the crimes charged that you're pleading to? Yes. The district attorney indicates this is what you did on the day. Do you admit that you did the above stated acts? Yes. Understand the full meaning of the guilty plea? Yes. I affirm that I have read the above statements in its entirety, blah, 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 and he signed it. I, Joseph D. Andrea, Esquire, attorney for Phil Godlewski, state that I have advised my client on the contents and meaning of this document. It is my belief that he or she fully comprehends the implication of pleading guilty and is pleading guilty of his or her own free will. And the lawyer signed it. Lackawanna County sentence sheet. Surcharge, corruption of minors, Commonwealth versus Philip Godlewski, case number 2613 CR 2010. Judge, clerk, district attorney Lafferty, defendant's attorney Diamora, or whatever his name is. On 7/11/2011, the sentence that you pay the costs of prosecution, that you undergo imprisonment, confinement in a Lackawanna County prison for a period of not less than 3 months, nor more than 23 months, and credit be given you as required by law for all the time spent in custody as a result of the criminal charges for which sentence is being imposed. Special provisions, no DA, DA, evac, all rec, no contact order, 18 age, less than 18 age, no contact with victim. No contact order with anybody under the age of 18. No contact order with anybody under the age of 18. And no contact with the victim. Legal fees for defamation lawsuit. So this is his GoFundMe. In November 2020, shortly after the general election, I felt in my soul that something wasn't right. People across the United States started being deplatformed based on their political beliefs. Proof of election fraud was being shown to the American public, although the mainstream media did their best to censor the reporting. I felt that I needed to start reporting the news as well. As a citizen journalist, I started doing live stream videos every day on Facebook. On the day of the inauguration, January 20th, Facebook suspended my account indefinitely. Twitter did the same. I was lucky enough to gain many supporters on other social media platforms. They have been by my side since November and followed me to more conservative social media sites. Recently, because my outspoken political beliefs and my rising popularity in YouTube, 100,000 unique viewers per video, my local newspaper ran an article and committed libel by referencing criminal charges were true that were ultimately dismissed. This has caused severe backlash against me and my family. 4 days after the article was published, I was fired from my job as a real estate professional. I'm now unemployed and have no means to support my family. The fundraiser is specifically for legal fees fundraising so that I can pay a retainer to the defamation lawsuit, a bad one. Defamation attorney willing to take my case. The cost will likely be more than $20,000, but if I can raise that much, I can at least get started with the lawsuit. Raise $26,396. Dear Tim, please find my client's supplemental responses to your deficiency letter. I apologize for the delay in getting this to you, but I acquired certain documents from Phil, which he sent me yesterday. They are attached should have any further questions. You have requested documents that do not exist. You are requesting plaintiff to produce documents which prove that the article is false and defamatory. The plaintiff was not in any way involved in January 6th assault on the Capitol. He did not write a blog, article, podcast, or broadcast any reference to the assault. This is nothing whatsoever to connect him with the assault. Obviously, therefore, no documents are available. As for the sexual relations or intercourse or sexual illegal intimacy, there are no documents because it never happened. The only document is what he pled to. You should know that a very detailed search was conducted by the police. When Godlewski was first accused and charged, it involved a search of his home and all his properties, which she had sold and or to which she might have access with the victim. His phone and that of his wife was forensically examined. Search warrants issued, a shotgun style. They picked up nothing. The investigation took over a year. At the preliminary hearing, the DA had no evidence but refused to drop the charges. Now, this is his lawyer saying this to the Scranton Times lawyer, but he's basing all this off what Phil told him. At the preliminary hearing, the DA had no evidence but refused to drop the charges. 1 year on, there was also no evidence. The DA still refused to drop the felonies and said that they would keep the investigation going for another year. During this prior year, Phil had been suspended by Real Estate Association, could not sell houses. He was almost bankrupt when the DA realized that he was going to go to trial and win because there was no evidence. The DA threatened to continue investigating for another year. Knowing that the damaged prior year had robbed Phil's income, had declined from $8,000 to $2,000 a month. On the advice of his grandfather, in order to be able to make a living, Phil agreed to plead to the corruption of minors. This was done because he could not continue to suffer the economic pressure. It was not done because he was guilty in any way. That doesn't matter. You pled guilty, so any newspaper that comes out and says you pled guilty is in the right. You can't say, oh, I just did it because this, and this, but I really didn't do it. Don't care. You pled guilty. This was done because he could not suffer the economic pressure. It's not done because he was guilty in any way. This is what he will testify to. I hope this explanation gives you some backgrounds you did not previously have. It also onto some other deficiencies you have raised. Phil was in Las Vegas when I spoke to him at the conference. He was promised to send me those tax returns, but was not able to get to them, immediate hold of them. I will follow up and get them to you. I haven't closed a confidential release document and apologize for the delay in the matter. There is an email discharging Phil, which, once again, he has in his possession, and again, I will follow up with him on the issue. There are no problems releasing his employment records. 9 through 12, Phil does not have any witness statements. We have not gathered any, and he's not independently solicited any. Neither have any been sent to him. Phil does not have any notes, diary, or recordings leading up to the article, which are relevant. He does have recordings in which he absolutely nothing is said regarding the January 6, 2021 assault on the Capitol. As stated, there is nothing that Phil has ever broadcast either for or against the events of January 6th. That's a lie. Neither has he fielded any calls regarding the matter. I think this has been addressed. We have no documents to prove a negative. His deposition will bear out the veracity of these answers. If he attended 2 years of college before going into real estate, he was at Regent University pursuing a master in the arts of law and alternative dispute resolution online from 2019 to 2022. He took an online course. He took a course of mastery and negotiation at Harvard Business School online. The plaintiff is making a wage loss claim. He lost his job with ERA and has not sold any property since that time. In addition, his followers were reduced by thousands. I need to get a handle on precisely what this number is, but with respect to his followers, that is not an easy prospect. I will get more information from you. I believe his recent tax returns should accurately reflect the loss. Wrong again, boy. Plaintiff has followers on YouTube, Facebook, Telegram, Rumble, DLive channel. The exact numbers of followers is determined by these sites, and we will get that information for you. Obviously, it has changed over time, but it seems to be in the tens of thousands. Not 6 million, not 8 million, not 15 million. He's lying about that, too.
We don't have this figure at present and shall determine if possible to provide it. There is some merchandise sold by Phil under license. We should be able to get that figure to you. We do not have it right now. These numbers are ascertainable. They are counted, so Phil's assertion is true, and he will get the information to back it up. The victim was a minor at the time, entitled to anonymity. There's nothing in the law which says her identity can be exposed when she reaches 18. Therefore, there's no law permitting a minor victim to have his or her identity revealed simply because he or she has reached maturity. Further, a victim of sexual abuse and a rape is entitled to continued immunity. We stand by our position. If you believe it's wrong, we will file a motion, and we'll let the judge decide. We believe exposing her identity is a violation of law. 19 through 20, Dory left February 17, 2021, right after the article was published. 24, plaintiff has this document, will provide it. 27, the details are these. Plaintiff's best childhood friend, Joe, was dating the victim. He was 21. She was 16. They were having a sexual relationship. Plaintiff did not know at this time, but apparently there was a threat to expose Joe. As a result, he unalived himself. The relationship between plaintiff and victim was only with respect to this discussions regarding Joe and his unaliving. This is wrong. How could she be 16 when she was with Phil when she was 15? This is probably why the victim pleaded the Fifth Amendment when asked questions regarding the case. Plaintiff 1 was 25, and all of this happened. In short, Phil's family life became non-existent. His wife left him, taking with her the minor children, who he has not seen since February. He has spent a great deal of money in divorce court in order to get just some visitation. The pain comes not simply from not seeing his children, but from his wife leaving him despite his innocence. Plaintiff cannot provide a complete list. A sample of the individuals who have an unfavorable view of his reputation were provided by your client. However, the plaintiff intends to do some statistical research to find out how extensive this is. This has not yet been undertaken. Further, plaintiff believes that in his industry, selling real estate, his reputation has been significantly harmed. Once again, plaintiff intends to research this issue more carefully. All a bunch of, we'll tell you later. Obviously, ERA is no longer doing business with the plaintiff. Plaintiff is seeking counseling because of the emotional injury. There are no physical damage. Plaintiff has medication prescribed for the adverse effect on the article. That was his answers to the questions.
I represent Chris Kelly, Tom Shamrock, blah, blah, blah. Preservation obligations. This is where they told him to discontinue all data destruction and backup tape recycling policies, preserve and not dispose of relevant hardware unless there's an exact replica of the file, a mirror image is made, preserve and not destroy passwords, decryption procedures, and company software, network access codes, ID names, manuals. This is where they're showing them preserve all electronic information because we're going to court. We're requesting Phil Godlewski preserve, not alter, blah, blah, blah. Of course, this is not what he did. He instantly went to deleting shit and lying about shit. Let's go on down. Dear Mr. Hinton, I'm the recipient of your reported preservation letter. First, I note that you sent the letter to me and to my client. It should not have to be mentioned that my client is represented by my firm, and therefore any attempt to contact me directly is a strict violation of the Pennsylvania's professional rules and responsibility. Oh, okay. Much of your preservation letter makes no sense. It looks as if it's been directly copied from the draft on your firm's word processor. Much of what you're requesting be preserved is overbroad, harassing, and has absolutely no bearing. This was his lawyer's only go-to. Overbroad, harassing, no bearing, and will not lead to evidence. Okay. He then says specifically, why would passwords, description, procedures, network access codes, ID names, manuals, tutorials, written instructions, decompression, and research, construction, software, etc. be of any value in this defamation case? Because that's what the fucking law says you have to preserve. Third, my client is not the defendant here. Criminal charges are public record, and he cannot erase them if he tried. In addition, his affiliation with ERA OneSource and any other information regarding his employment can be properly obtained through subpoena. Any PA Department of Revenue liens are also public record, and I look forward to you explaining how many of these documents could be relevant to the case. As for any videos he has posted on YouTube or other social networking platforms are also available through discovery, although their potential relevance to this case has not been explained or described. In short, it appears to be overbroad nature of your letter that makes it more harassing than relevant. With that noted, I would emphasize that my client has absolutely no intention of deleting any information, which might be in any way applicable or important into this case. In the same vein, by this letter, your clients are cautioned not to destroy, conceal, or alter any paperwork, electronic files, or other data generated by and or stored on any of the computers used by or having been used by Chris Kelly, Time Shamrock Communications, Scranton Times Tribune, Larry Holeva. This is also pertains to any relevant computer systems and storage media, hard disks, clouds, backup tapes, USBs, or any other electronic data such as voicemail. This also includes but is not limited to email or other electronic communications, word processing documents, spreadsheets, databases, calendars, telephone logs, contact manager information, internet usage files, offline storage or information stored on movable media, the cloud, information contained on laptops. Sure, give him a warning back. Discover will be found in printed documents. Therefore, even where a paper copy exists, we will seek the documents in electronic form. We require preservation of all source information. We also require statements, voicemails, phone numbers, lists of individuals spoken to, and any other information, including due diligence. As you're aware, the laws and rules prohibiting destruction of evidence apply to electronically stored information in the same manner they apply to other evidence due to its format. With regard to electronic data created subsequent to the date of the delivery of this letter, relevant to evidence should not be destroyed. Please forward a copy of this letter to all persons and entities with custodial responsibility. Failure to abide by this request. So his lawyer was trying to bluff, but he's dumb. I don't know what to say. Enclosed are defendants set 1 to questions directed at the plaintiff above. This is where he answered the questions. Let's scroll down. State the following: your name, blah, 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 marriage, state your gross income, how many followers, how many, whatever. These are just the questions here without any answers. I started filing the 9th day, 2021, cause true and correct copy of set 1. Okay. Plaintiff generally objects to defendant's questions to the extent they are ambiguous, vague, overbroad, and unduly burdensome. Plaintiff objects, plaintiff objects, plaintiff objects. Accordingly, these answers are made without prejudice to plaintiff's right. Plaintiff objects, plaintiff objects, plaintiff objects. This is when Phil was refusing to fill out any information. Your full name and any other name by which you're known by: Phil Godlewski, Philip Godlewski, Philip Godlewski. Date of birth, objection. Social security number, objection. Present marital status, separated. Set forth address, objection. Objection, objection, objection. Set forth in detail about educational background, some college. State your gross income for each of the calendar days of 2011 to present. Objection. How many followers did you have on YouTube on February 14th, 2021? Approximately 27,000. How many friends do you have on Facebook as February 14th, 2021? 38,000. How many followers did you have on Twitter February 14th, 2021? Doesn't know. How many followers did you have on Telegram? 15,000. How many followers did you have on DLive? 10,000. How many followers did you have on Instagram? 1,500. What is the factual basis of Philly Godlewski's averment in paragraph 2 of the complaint? For the purpose of this complaint, by virtue of his large following, Mr. Godlewski is a public figure. Objection. How much revenue did you earn or receive from YouTube in each month in the last 2 years? See below. So he made a month that says like he made 4,000. Your estimated revenue. Let's see. Total. Oh, the total for January, February, March, April. The total for the whole year he had made 4,000. It looks like. How much revenue did you earn or receive from DLive each month during the last month? See below. It's blacked out. How much revenue did you earn or receive from Telegram? 0. How much revenue did you earn or receive from Starve the Beast? $20,000 for each month. He was making $20,000 on Melaleuca each month. How much revenue did you earn or receive from Bonfire, the Patriot Store, in each month? 11,000. Did you send a text message to Chris Kelly stating you have over 75,000 followers in February 2021? What proof do you have this assertion? Yes, plaintiff objects to the request for pure proof on the basis that it is a legal conclusion. Plaintiff does not know what constitutes proof. Identify the girl by name you allegedly had contact with, alleged criminal charges being filed against you in 2010. Plaintiff objects. Describe your relationship with Thomas and Nesla. This question is based on the basis that it's vague. Furthermore, relationship is irrelevant to litigation, not directed to lead to discovery of admissible evidence. Objection. Plaintiff did not have a relationship. When did you get married to Dory? 9/29/12. Provide the dates of any separation from Dory. Objection. On what date did you and your wife Dory separate for the last time? Objection. Where did you reside June 1st, 2021, and who resided there with you? His house. In what county did you divorce action filed? Luzerne. On what date did your employment or working relationship with ERA Realty terminate? 2/18/21. Did ERA Realty send you a termination letter or email terminating you? Email. Describe all your sources of income as June 1st, 2021. YouTube, DLive, Bonfire. Describe the financial support you provide to your wife, Dory Gallagher, and your 2 children at the present time. The support order requires a plaintiff to pay $1,000 per month. He's paying $1,000 in child support. What did you plead guilty to? Corruption of Mountain or 2011. Why did you? Objection. On what date did Riverside School District terminate service as a baseball coach? Not terminated. Other than your convictions of corruption of morals of minor, tampering with records, and writing a bad check, have you ever been convicted of any other crimes? Plaintiff was convicted of driving under the influence, DUI, in 2002. No record was entered because he successfully completed ARD. So Phil's got a DUI. I never brought this up because it was so old. But Phil has a DUI that he was charged with in 2002. He went to court at 2003, and he completed some type of course that nullified it. What trips outside the Commonwealth of Pennsylvania have you made since February 14, 2021? State the purpose of your trips and identify any persons who accompanied you. Objection. State the names of any people who contacted you since February 14, 2021 who stated they thought Chris Kelly's article was published on February 14th contained lies about you. There are in the hundreds, possibly in their thousands, therefore naming them is impossible. Did the 15-year-old victim who was the subject of 2010 criminal charges touch you in a sexual manner at any time? No. Do you have any letters or emails? None. Did you give any gifts to the 15-year-old girl referred to in the defendant's article? If yes, please state what they are. Plaintiff does not recall giving her any gifts. Identify all lawsuits in which you have been named as a party since January, blah, blah, blah. Can't be sure. How much money have you raised in donations to GiveSendGo or any other platforms to pursue this lawsuit? Objection. Do you have a listing of the names of all your donors to pursue this lawsuit? Objection. Identify all persons who believe you have unfavorable view of your reputation due to February 14th. Objection. Identify all recipients of allegedly defamatory statements who have exposed plaintiff to public hatred, contempt, and ridicule. Objection. Identify any persons who refuse to do business with the associate or plaintiff as a result. Objection. Identify any persons whose opinion of the plaintiff's reputation was affected by this article. See the previous answers where we objected to all of them. They actually say things like, is objected to on the basis of blah, 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 by way of further defendant has access to numerous views or to a number of views at the Scranton Times, blah, blah, blah. Cannot meaningfully respond to this question at the juncture proceedings by way of further answer. Defendant received hundreds of threats of harassment on social media. That's a lie. From anonymous users, which spiked after the article was released. In addition, blah, blah, blah. State all damages suffered or claimed by you in this case and how the damages were corrupted. Objection. Plaintiff is claiming so far unspecified damages for pain and suffering and for damages of reputation, including punitive damages. Plaintiff is also claiming economic loss, having been released from his job as an independent contract and real estate professional ERA, one source realty because blah, blah, blah. Additionally, plaintiff's online reputation has been severely damaged. Are you claiming damages for physical, psychological, or emotional injury? Yes. The name of your physician or other healthcare professional you have consulted for treatment in the last 5 years. The date or dates which treatment was given. The sums paid for such services, $700. Diagnosis rendered blank. Any drugs prescribed blank. Details of any other treatment. Identify all documents in which record relate to refer to the matters inquired medical records. State whether you consulted a physician or a healthcare professional for any treatment as a result of publication at issue. If so, state the date, blah, blah, blah. Identify answer C 43 above. With reference to this publication at issue, set forth each sentence in the article which you contend is defamatory. Defendant is referred to the complaint which speaks for itself. Identify each witness who will provide evidence in this case. Plaintiff has not yet determined which witnesses he will call and what evidence he will submit by way of further. By the way, before you go to court, you have to know all the evidence. You can't bring in a surprise witness. Both sides know all the witnesses. So him saying, I haven't identified all the witnesses yet, is just bullshit. It's just bullshit. You're basically saying, I'm not fucking ready, and I filed the suit, and I'm not moving forward. Identify all persons with knowledge as the subject matter of the article for each person's state, name, address, blah, blah, blah. Objection. Identify each witness by name, address, telephone number, occupation, present employer. Objection. Each document or tangible object which each witness will likely be identified. Identify each and every document or tangible object which you intend. Objection. There's a verification, and that is not even his signature. That's done through DocuSign, but whatever. Set 1, propound upon plaintiff in the above referenced. This is where they're asking more questions. Plaintiff, Phil GODLEWSKI, term concerning menu to referring to. Signature shall include, in the event any documents covered, documents requested. This is all the documents requested. Produce all documents requested to claim February 14th. Identifying the claim contained false or defamatory statements if you're making a claim for lost wages. This is all them asking for the documents. From the Scranton Times, the first set of documents. Plaintiff generally objects. Plaintiff generally objects. Plaintiff objects. Plaintiff objects. Plaintiff objects. Plaintiff objects. The document request is objected to because it's vague. These will be provided. Another bullshit answer. See answer to number 2. They will be provided. Bullshit answer. Plaintiff does not have his medical records. That's not good enough. Go get them. See answer 4. Plaintiff is not in possession of these personal employment records. Too bad. Go get them. This document request is objected to. Plaintiff is in the process of collecting them. They're little hundreds. This is evidence of harm to his reputation. Any complaints from other lawsuits filed by the plaintiff? None. Any and all statements concerning this action defined by Rule 4003.4 from each and every witness? Objected. Any and all documents containing the name and home business address of each individual is considered a potential witness. Objected. Any and all statements, descriptions, and summaries? Objected. This document is objected. Plaintiff has not determined whether he will hire an expert witness. Plaintiff has not determined which fact witnesses. The document request is objected to. Document request is in violation. Plaintiff has not prepared a resume. So see the responses to document requests herein. Any documents sent from the 15-year-old girl referenced in the article? None. Any gifts? There were no gifts. Any documents concerning any gifts, including a vehicle you purchased for the 15-year-old girl. No gifts. All documents related to Exhibit A of the complaint. Objects. All documents relating to publication. Objects. Any and all documents contend to establish any element of plaintiff's claims being made. Objects. And this is why he can't win the fucking case. He's not providing any documentation. If you're going to object, you need to go to the fucking judge and say, hey, this is why we're objecting. We need you to rule that we don't have to answer this. The judge ruled you do have to answer all of these. Enclosed the defendant's request for production documents, set 4. This is one of the most recent one. Plaintiff. You means the plaintiff, blah, blah, blah. This is set 4. Text messages, blah, all that stuff, right? This is the one we read pretty recently. By the way, Phil GODLEWSKI is trying to say I've got egg on my face because they're being disposed. General objections. Produce any certificates or diplomas. Plaintiff objects. Transcript from hearing before Judge Garello. Does not have it. Produce transcript of hearing before Judge Garello. Again, not have it. Transcripts from preliminary hearings for the case in 2010. Does not have it. Produce copies of any text messages, cell phone records. Does not have them. Producing text messages between Phil and Thomas Neslow. Plaintiff has never communicated in any way with Mr. Neslow. No such text message exists. Not true. Produce any text message between Phil GODLEWSKI and the victim. Plaintiff does not have any. Produce any records sent to or from Pennsylvania Real Estate regarding plaintiff objects this request. Produce any records showing the funds received by Philip GODLEWSKI from the sale of his interest in the agency, Valley Home Loans, Velocity Abstract, Nepa Real Estate Academy, or Subway. Plaintiff objects. Produce any records from blank, attached. Produce any records from blank, attached. Produce any records from private investigator hired by Phil GODLEWSKI. So this is where he claimed he hired a private investigator, and they found out that just a bunch of girls got together to set him up because they were conniving. No documents exist. Wow. Imagine. He told me he still had all the evidence, and he was going to prove this in court, that he hired a private investigator, and they proved that these girls used a internet text messaging app to make him look like he had a sexual relationship with one of them. Now, I don't have them. They don't exist. Objection. Got it. We got to get down to the good stuff. So here's another question, another set of questions. Please identify the members of plaintiff's security detail at any time during the years. Oh, this is going to be a good one. Let's get down to the answers. Please identify the members of plaintiff's security detail at any time during the years of 2009 and 2010. Plaintiff did not have security detail at any time during the years of 2009 or 2010. Does plaintiff still have this phone number in use? Yes. Does plaintiff have possession of the actual cell phone he used for number? No. Has plaintiff communicated with his wife, Dory, about his lawsuit? Yes. Plaintiff does not recall specific dates of communication. Plaintiff communicated via telephone and in person regarding the effects of defamation on the plaintiff's children. Plaintiff and ex-wife discussed how to navigate the very defamatory statements made by the defendant, Kelly, with regards to children's schooling, their teachers, their friends. Has plaintiff communicated with his mother? No. She doesn't speak to him. Has plaintiff communicated with blank about this lawsuit or his damages from this article? Yes. Plaintiff does not recall the specific date of communications. Plaintiff spoke with blank in person regarding the filing and warned that it was imminent. Plaintiff asked if she would rather plaintiff forego the filing so to avoid any stress in her life. The victim said to file so they could both set the record straight. This is Phil being the white knight. This is all a fucking lie. This is all a lie, as she's going to testify to. Fucking. Here we go. Phil GODLEWSKI, blah, blah, blah. Court, jury, trial demanded. County of Lackawanna. I blank, an adult individual who resides at blank, being duly sworn to law, hereby swears and affirms the following. My date of birth is blank. A copy of my driver's license is attached to this affidavit. I was a minor victim in the criminal case brought against Phil Godlewski in July 2010. In September 2008, I began 9th grade at Riverside High School at the age of 15 years old. On November 10th, 2008, my boyfriend, Joseph Strzok III, unalived himself. I was very upset by his death. Shortly before Joseph Strzok's death, I met Phil Godlewski. I began communication with him after Joseph's death. Phil Godlewski was 10 years older than me. Within a couple of months after Joseph Strzok's death, I began having a sexual relationship with Phil Godlewski. I was 15 years old when we started our sexual relationship. Phil Godlewski bought me gifts, including jewelry, a hat, and other items in the first few months of our relationship. Phil Godlewski and I had sex multiple times while I was in 9th grade and 10th grade student at Riverside High School. Phil Godlewski was charged with crimes relating to our sexual relationship in July of 2010. Phil Godlewski and I continued to communicate with each other while the criminal case was pending against him. After Phil Godlewski was arrested, he pleaded with me not to testify against him and said he would unalive himself if I testified against him. By the way, something I've been holding on to is the only reason that fucking Dory stuck around is because Phil claimed he was going to she kicked him out. She kicked him out. He went to a hotel room and called her and claimed that he was going to unalive himself, according to her. And she let him come back to the house for that night and left in the middle of the night with her fucking children. So he could at least have the house and they wouldn't have to see their dad on the news unaliving himself because of mistakes he made. Phil Godlewski and I continued to communicate with each other in criminal investigation. After he was arrested, he pleaded with me not to testify against him and said he would unalive himself if I testified against him. In response to Phil Godlewski's pleas and just wanting the situation to end, I stopped cooperating with the district attorney's office. Where's this? Oh, wait. Where's this highfalutin, fancy-pantsy lawyer she hired from the city that come down and said she pleads the fifth? Where's that at? I stopped cooperating with the district attorneys. She was manipulated. She was given gifts for pussy at 15 years old when he was goddamn 25 years old, while he had the power dynamic in his fucking favor. And then when he was held responsible for it, she was manipulated into fucking not cooperating in his prosecution. And I refused to testify against Phil Godlewski at the preliminary hearing at the case. Phil Godlewski and I continued our sexual relationship in the 2014-2016 time period after his criminal case was over. Dory, can you tell me who you were with in the 2014-2016 time period? Hello, Dory. Question for you at the door. 2014, 2016, they were still fucking behind your back. Hey, Carrie, where are your girls at? I, blank, do hereby swear and affirm that these statements made in this affidavit are true and correct to the best of my knowledge, information, and or belief. I am a sound mind, and I make this affidavit of my own free will. I understand that false statements herein are made to subject penalties 18 PACSA 490. Phil, you're going to fucking criminal trial, bro. You're going to be held criminally accountable for this. Riverside High School, for Mr. J. Mosianis, principal at Riverside Junior High School, for Mr. Paul Blank and Miss Linda Blank, relationship between Phil Godlewski and our daughter Blank. Per your request, we are stating the distributing a fact that we have recently become aware that our daughter Blank, 15 and a freshman at Riverside High, has been engaged in a relationship with an adult male employed by Riverside School District. His name is Phil Godlewski. Our daughter has admitted this relationship to both of us, as well as to her counselor. From November of 2008 to the present, she has received numerous gifts from this man, including diamond earrings valued at $2,859 from Zales, a diamond and sapphire necklace, $289, an expensive hat, $95, as well as some other items. Linda has heard them speaking on the phone and has phone records to prove it. They have spoken and texted during school hours throughout the day and long into the nights. The relationship is clearly inappropriate, and we fully support any action taken by the district as a removal of this man from the coaching staff. Thank you for your attention to this matter. Signed, her parents, Paul and Linda. Uh-oh. This says, I'm sorry your pop died, but I'm pretty sure we had sex on their bed. Here it is. I think we had sex in the bed, though. I'm sorry your pop died. I think we had sex in their bed, though. Oh, no. But yes, we did. And I mean, it makes sense considering we probably had sex in like 40% of the homes in northeastern Pennsylvania. What number's that? From 570-780-4567. Oh, that's Phil's underage pussy line. We haven't been all up under each other in so long. Weird. Damn, I can't read that one. Yeah, I think it got bigger. Not sure if that's a thing, but it feels like it did. His penis is all grown up. You want to go to Oklahoma? Harry, Dory, where you at, though? Man, I mean, I feel better that she's gone, to be honest. The sex sucked or was non-existent, or always one of the two. She was constantly miserable. She wasn't even really a great mother. The kids always wanted to be with me and not her. It was a disaster. Carrie, how's that $7K fucking hush money tasting? Huh? I think it might be I think it might be fair to say there's a very, very large and very, very unique financial opportunity. Talking about for both of us, talking about the case that was coming up. Laugh out loud. Appears to be hardly anyone. That happens to hardly anyone. The type of opportunity that happens to hardly anyone. So this is where they're talking about making $5 million by committing perjury against the fucking newspaper because Phil told us that this girl was going to come out and testify on his behavior, on his behalf. And wait till they see the witnesses, he said. Okay. The type of opportunity that appears so rarely, hardly for anyone. Dude, I know it makes me want to throw up. And everyone knows but me. A mom something can't look me in the eyes for more than 1 or 2 seconds. This is sad the way he manipulated her. Because everyone knows but me, it seems like. I'm about the same thing. Something, I'm about the same thing. Laughed at. I don't think we're talking about the same thing, Mrs. Oh, so he put, I don't think we're talking about the same thing, Mrs. Oh, are you trying to recruit me for the silver thing? Oh, this is, we really need to meet and chat. This is where he's trying to get her to perjure herself. No. We can't talk about this through text or over the phone. I can meet up and see. I can't meet up or see anyone right now. I'm going through some stuff physically and basically doing a cleanse on my system and got my period yesterday. And I'm barely walking. I'm barely walking. Doesn't have to be today. Some physical stuff. What the fuck? You're dodging me. No, I'm not. No one will ever understand what I just went through this semester. I'm kind of worried about you. Why? Crazy something doesn't seem like doesn't seem like you that I know. You're talking kind of crazy. Doesn't seem like the person I know. No, I'm very okay. I just legit went through 8 months of something and ended like days ago. So I'm trying to do the right thing and get my mind and body in order and detox off the medication I've been on since I got sober 6 years ago. And it doesn't help. All my accounts got hacked, and I can't talk to anyone about anything until I have my answers about what exactly I'm going to be doing for work, which will be on Tuesday. I'm honestly just exhausted and healing, truly. Oh, well, that makes me feel better. When you're ready, I have an opportunity that's something, both of us, but it won't work with just one of us. I don't know which way to go until I speak with you, so remember me when you feel better and want to talk. I know I've been wanting to talk to you about almost the same thing, weirdly enough. I've been the one who has wanted to square things up with you that nothing to do with romance or Amanda that would save both of our reputations, but I didn't plan on talking to you about anything until school stuff was over. I got a something in my I'm in stone. I'm sure Amanda told you a little bit, which is okay because I wasn't a secret. Not that you were lives dragged through the mud for years together, and it has affected us both professionally to the point where my internship was based on my ethics and morals, but I passed with flying colors, and I'm pretty sure I may have gotten almost a full ride to get my MSL in data and privacy law. So yeah, I'm okay, and I know you've had to defend yourself for years, which a lot hasn't had to do with me, but I don't like that people make it something you were some creep or I was some homewrecker little tramp, and I like us having each other's backs in some regards. So because she wanted to have a relationship, it doesn't make it okay, but because she wanted to have a relationship with her, they devised this plan. I agree, but it's a very, very delicate situation. Unless it's handled properly by both of us, we stand to benefit absolutely nothing, and there's a financial windfall here if handled properly. That's all I can say really through text. I just don't trust those motherfuckers, and I have something to take them down once and for all. I will be suing the Scranton Times-Tribune for defamation and libel. I was hoping the reporter would do exactly what he did. He took the bait. In close, their defendants set 4 directed at plaintiff above referenced. This doesn't, let's go see if we can have the answers. Down at the bottom, we're almost through with this, but then there's one more, which is 6 pages. General objections. What year did you first become a real estate agent? 2007 or 2008? So by the way, he wasn't a top real estate agent for 25 years. What year did you first meet Carrie? August of 2021. What year did you first meet Carrie in person? October 2021. She come to stay at his house for a week. What is your custody schedule for your children? Plaintiff has 50% custody of his children. Did you have a sexual relationship with Miranda Polidori at any time? Yes. If yes, when the sexual relationship with her and how long did the sexual relationship last? Plaintiff had a sexual relationship with Miranda Polidori for a month or 2 in 2018. Does not recall the specifics. Oh, Dory. Did you have a sexual relationship with Amanda Torini at any time? No. That's the Amanda they were referencing earlier. Amanda Torini, which is friends with the minor victim. Did you have a sexual relationship with blank at any time? No. Yeah, you did. Multiple times. And the verification. So that is it from their motion. That's all their evidence. That's here you lied. She's working with us. You better back off. And you're probably going to face criminal charges. Now let's move over to this. This is the document. This is their actual motion, what they're asking for and everything. Here we go. Plaintiff Phil GODLEWSKI filed this defamation case on May 24, 2021. He alleges defendants defamed him in an article published on February 14, 2021 and seeks $5 million of damages. By virtue of him being a Patriot reporter and social media influencer with over 75,000 followers, plaintiff claims in the complaint he is a public figure. The article in question discusses plaintiff's criminal history and states Lackawanna County detectives said GODLEWSKI had sex with a minor girl in cars and homes he had access to as a real estate agent. Further, the article noted he pled guilty to corruption of minors and admitted to having a sexual relationship with a 15-year-old girl. GODLEWSKI, 28 at the time, was sentenced to 3 to 23 months with the first 3 months to be served under house arrest and the balance as probation. Plaintiff now claims in his lawsuit he never had sex with a 15-year-old girl, and the defendants defamed him by stating as such. A substantial amount of written discovery so far in this case has focused on plaintiff's relationship with a 15-year-old female, victim of 2010 criminal charges against plaintiff. Should defendant's section motion be granted? Suggestion, yes. Argument. The purpose of Pennsylvania discovery rules is to prevent surprise unfairness and allow a fair trial on merits. To that end, PARCP 4003.1 provides that as a general rule, discovery is liberally allowed with respect to any matter not privileged, which is relevant to the cause being tried. PACSA 25037 permits a party to request a reasonable counsel fee against other party for dilatory, obdurate, or vexatious conduct during the pendency of the matter. 4019 permits the court, upon motion, to make appropriate order for sanctions if a party fails to serve answers to the questions or fails to produce documents requested under Rule 4009 or fails to obey any order of the court respecting discovery. With respect to spoliation issues, the Superior Court has explained spoliation of evidence is the non-preservation of a significant alteration of evidence for pending or future litigation. When a party to a suit has been charged with spoliation evidence in the suit, sometimes called first-party spoliation, we have allowed trial courts to exercise their discretion to impose a range of sanctions against the spoliator. This is about him getting rid of evidence or not producing evidence. The trial court must weigh these factors: the degree of fault of the party who altered or destroyed the evidence, the degree of prejudice suffered by the opposing party, whether there is a lesser sanction that will avoid substantial unfairness to the opposing party, whether the offending party is seriously at fault, will serve to deter such conduct by others in the future. In assessing the degree of fault of the party who altered or destroyed the evidence, the trial court must consider, 1, the extent of the offending party's duty or responsibility to preserve the relevant evidence, and 2, the presence or absence of bad faith. Where fault and prejudice are not severe, dismissal is inappropriate. Although an order granting summary judgment against the offending party remains an option in some cases, its severity makes it inappropriate remedy for all but the most egregious conduct. So if they don't believe they're acting in bad faith, they're saying you probably shouldn't dismiss the case if it's an accident, if they forgot, if the email got lost, if they have an excuse, not if they've been ordered and asked 15 times and lied about all of it and then went behind everybody's back to try to get their victim to perjure themselves in court to get you $5 million you can split with them. The fact that plaintiff of misconduct in discovery and his failure to preserve and produce evidence is set forth in the defendant's motion, it is clear in this case the plaintiff's conduct was intentional, fraudulent, egregious. The severe sanctions being sought by the defendants are warranted. Wherefore, defendants respectfully request the following relief: plaintiff's case be dismissed with prejudice, and defendants be awarded $35,000 from plaintiff as a reasonable counsel fees, and another $35,000 for plaintiff's bad faith conduct due to plaintiff filing of this lawsuit, failing to preserve evidence, providing false discovery responses, and for suborning perjury from a material witness. Respectfully submitted, Haggerty, Hinton, and Cosgrove by J. Timothy Hinton, Jr., Esquire. And that is the culmination of when you lie and cheat and steal and grift from your following to try to set up a fake court proceeding where you try to manipulate your now adult victim into helping you by paying her off. Take me to court, motherfucker. You admitted to it. You had sex with a minor, and she's now on the other team. Good luck, fucker. Guys, have a good night. Thank you for joining us. If you got something out of the show, you appreciate it, go to coldbeer.fun, like, share, comment on the video. I'm out of here. Got places to be in the morning. Have a good night. excuse me if I looked unprofessional during this recording. Someone had said that I had, I'm not sure if it's true or not, but someone had said that I'd apparently had egg all over my face. I want to apologize for that. If you follow Phil now, you're just as manipulated as his sexual abuse victim. Happy Thanksgiving, Phil, you fuckstick. Oh, a financial windfall for both of us if you lie again. I can't tell you in text message about it, though. Fucking Menza right there. Menza. I think we can both fuck the paper out of $5 million, but we better not text about it. They might figure it out.